Hello and welcome to the latest video dealing with the issues of deportation, third in a series that myself, Emma Rutherford and Stephen Vokes from Number 8 Chambers have done together, discussing various issues relating to deportation. This is an area where there's often quite significant changes and numerous new cases, and yet again we've had a number of deportation cases in recent months that we thought it would be useful to talk about. As always, this video is intended to be a discussion of legal issues. It's certainly not intended to give any legal advice to anybody, and it is our opinions and our views only as to the case law and what it says. Stephen, over to you in relation to where we're at. I think the last video we did, we were talking about HA Iraq and the decision in that case by the senior courts.
Yeah, and what's happened since is, in fact, since there was a fairly comprehensive analysis in HA Iraq, and there's been a number of cases since, the latest being KB Jamaica against Secretary of State, 2020 ECWA Civ 1385, which effectively endorses completely the views in HA Iraq.
Yes,
and it's interesting. Yeah, it's interesting that Lord Justice Popperwell, who gave judgment in another successor case from HA Iraq, did in fact essentially give the judgment here. Paragraph 15, I think, is the relevant paragraph, and it's very clear that two things arise. As we've said before, that firstly, there's no ordinary level of harshness involved, unlike what we know the upper tribunal used to insist upon. And secondly, there's no principled reason why there shouldn't be rather a lot of cases where it would be unduly harsh for the children to have to leave the country, or indeed be separated from their parent, whichever parent it is being deported. And all I would say is, again, the tribunal, or rather the Court of Appeal, the bench, tended to take a view that was akin to Article 8 in some ways, because they said there was an infinite range of circumstances to be taken into account, and there was a need for careful evaluation. I think, Emma, what they're driving at here again is the checklist, which was actually put forward by Lord Justice Underhill, the Vice President of the Court of Appeal, Civil Division, in HA Iraq. But it does now seem to me that the judiciary, the first tier tribunal judiciary, and indeed the upper tribunal, have to look very carefully at the existing circumstances of each individual family where there's a deportation involved.
Yes, I think that's got to be right, hasn't it? And the acceptance that there is an infinite range of circumstances. It's all very much now a fact-specific exercise, isn't it? With, albeit the checklist from Lord Justice Underhill, where you have certain factors which, of course, you must take into account and consider. But in any case, there's going to be fact-specific issues that may tip the balance in that case.
I would say this: it is hard to see if a first tribunal judge takes into account all the factors in a case and indeed does a checklist approach, that any view they come to as to whether it was unduly harsh or not is not really that appealable to the upper tribunal.
No, I'd agree. If all relevant factors have been considered and no irrelevant factors have been considered and a rational decision's been reached, it's very difficult to see how anybody could successfully appeal that decision.
Yeah, because there was a whole, as you're well aware, Emma, there was a whole period of time when basically the first tier tribunal used to allow a case on its facts because it was unduly harsh. And basically the Secretary of State always appealed to the upper tribunal, usually on the basis that it wasn't an elevated level of harshness involved. And therefore they got the law wrong.
And in fact, that was one of the grounds in KB that they took, was that the wrong test had been applied. The elevated threshold had not been applied. But the Court of Appeal obviously said, well, now obviously, I mean, there was a change of law and fairness in terms of we had HA between the grounds being drafted and admission being granted and the case being heard. But what's quite clear from, you know, HA and KB is that we are very much now looking at a range of factors. There's no ordinary level that's acceptable. You've got to just look at all the factors and decide whether on those factors it's unduly harsh. And all those grounds that used to be submitted on the basis of, well, the judge obviously hasn't applied the appropriate test because, hint, hint, judge in the upper tribunal, how could this be allowed? Surely now won't succeed.
Well, one would hope not. What was very clear to me in the last period, where in fact there was still this high level of undue harshness being applied by the upper tribunal, is that it was very much a conscious decision.
Yeah. That
you go there and they would say, well, you know, it's just the ordinary degree of a child being separated from its parents. Now, what is on top of that? We're looking for a very elevated standard. And indeed, I've had experience whereby the Secretary of State has appealed a decision and they haven't actually appealed it on undue harshness. And I've had upper tribunal judges saying, well, if it was for me and if the Secretary of State had put a ground in on the question of undue harshness, I certainly don't think the test is met in this case. And it's just simply because it wasn't appealed on that basis. And I consider that one hopes, and there are certainly very capable legal brains on the upper tribunal, that they are now clearly aware of the change of approach on this issue, given that we now have 3 or 4 Court of Appeal cases which endorse the HA-Iraq, KB Jamaica being the latest one.
Yes, the latest in a number of decisions that we've had on that. And as we've discussed before, it seems perfectly sensible that, you know, different children are going to be affected in different ways by the deportation of their parents. So you have to have a holistic assessment of all the factors, and there isn't what may be acceptable for one child isn't necessarily unduly, or may not necessarily be acceptable, or should I say unduly harsh in respect of one child isn't necessarily, start that again, something that may be unduly harsh in respect of one child may not be in respect of another.
That's right. But what it actually requires for those people representing appellants in these type of deportation cases is an attention to detail to show that everything about the child's circumstances and the relationship with the parent to be deported is actually thrown into the mix. And that is, of course, an evidential job to be done. It's not good enough to say the child will suffer because father or mother's not here. It's a question of how and what. And of course, the more evidence which is put forward, the more it has to be evaluated.
Absolutely. Don't think there's much more we can say about that at the moment. We've also had some interesting cases in relation to the serious harm test, case of Wilson in the upper tribunal, following on from the case of Mahmood, very early part of 2020 in the Court of Appeal. And that has some interesting comments made by the upper tribunal in relation to what constitutes serious harm for the purposes of the serious harm test when looking at whether someone should be deported.
As I understand it, Emma, basically, you've got to actually carry out actual bodily harm, so to speak, rather than just the potential. I believe
Absolutely.
that Wilson was a case with a chap carrying a knife. Was that correct?
Yes, he was found in possession of a knife, and he was stopped and effectively told he was going to be searched by the police. And he said, well, I've got a knife on me, and handed it over to them. No suggestion he was brandishing the knife, no suggestion he threatened anybody. He was in fact carrying it because his uncle and cousins had been attacked with a knife, so he was carrying it for self-defense. Now, obviously, we all appreciate the harm that is caused by the carrying of knives is that they then end up being used. But there was no suggestion in this particular case that this knife was brandished or used to threaten anybody or harm anybody. And he got 6 months imprisonment for the offence. The judge obviously sentencing and making reference to the reason for that, the potential harm, and it is sadly a feature in many cities that young people carry knives and they get used even if they weren't really intending to. So it's met with a criminal sentence. Of course, that didn't trigger the 12-month automatic deportation provision. So the Secretary of State relied upon his offence caused serious harm. And what's interesting in Wilson is what the upper tribunal said was actually, no, it didn't cause serious harm. And you can't equate a serious crime, which it clearly was, with serious harm being caused. And the test is very clear. It's caused serious harm. Now, that can be physical harm, it can be emotional harm, it can be economic harm. But there needs to be a serious harm caused by that specific offence and not by that class of offences. Which I think is an interesting point from the upper tribunal when looking at those kind of offences, and may have implications for example, drugs offences, where someone has been in possession or intending to supply. They often say in deportation letters, as you know, Stephen, that drugs offences, very serious offences, cause a lot of harm to society. And whilst there may not be a difficulty with that, where you can show that someone's quite heavily involved in the drugs trade, someone convicted of a minor drugs offence, or say a series of possession offences, you may find it difficult to say there's been serious harm there if that's the route the Secretary of State goes down.
Yeah, absolutely, Emma, because basically when you read, forgive me for being cynical, but when I've read just about every single deportation letter, it requires the offence of it caused serious harm. And we're talking about drugs, we're talking about violence, when, yes, it may be against the law, it may be rather regrettable, but, excuse me, it certainly didn't actually cause serious harm. And it's what I'm polemicizing against is a formulaic approach whereby they put that sentence in regardless of the crime committed, rather than actually looking at the situation.
Absolutely. And the tribunal in Wilson made a number of other quite interesting points about what needs to be shown for the approach to be taken to serious crime. And comments like the Secretary of State's view is a starting point that it's a serious crime. You need to look at the sentencing judge's comments. You need to look at particularly how the judge categorises the offence into the judicial sentencing guidelines, because there are different categories of seriousness for offences where there are guidelines in existence. And they make comments about the evidence that can be produced dealing with it. They say it's unnecessary necessarily to have the victim of the offence there, but the appellant's evidence on the serious nature of it should be treated with circumcision, circumspection, I should say. And they deal with they deal with all these points about the need for it to be actual harm, not real, not a risk of harm as such. One other interesting point that they make is in relation to the approach to Article 8 as well. I don't know if you noticed that in relation to the point about allowing it on the basis it's on one of the intermediary tests on Article 8. So when you get to is the decision in accordance with the law, so step 3, which is what happened here, saying, well, actually, that's a shortcut and it's dangerous, and really you need to go on to determine proportionality.
Yeah, I mean, there was a fashion once upon a time where we got to the 3rd step, and is it accordance with the law? And basically, rather than carry out a proportionality exercise, what tended to happen where judges were saying, well, actually, it's not in accordance with the law because I found contrary it will breach Article 8 rights without actually spelling out and going through a proportionality test. And as you say, Emma, it was treated as a shortcut. And
the danger, as identified in this case, was, well, hang on a second here. It actually, the power to deport him comes from the Immigration Act, and the power to do so is that the Secretary of State's decided it is conducive to the public good, not that he's a serious criminal. That's not necessary, or committed a serious offence an offence that causes serious harm. And of course, they also make the point that the appeal isn't actually against the deportation order, it's against the refusal of the human rights claim. So the fact he didn't meet the criteria for deportation under the automatic deportation provisions didn't actually dispose of the appeal. So in this case, it was one that was remitted back to the same judge to determine. And I think we can guess which way it was going, but it needed to be properly determined.
And cannot be allowed on the basis that the appellant should not be deported. That is a mistake one comes across, that basically the representations on behalf of the appellant stop at the point about why he should be deported. And obviously, they're usually around family, private life issues, but it's not actually spelled out because they don't deal with the proportionality of the public interest in removal under an Article 8 exercise. And that is where the difficulty comes. Because there's one thing, as you say, not making out the grounds for deportation. It's another thing in actually showing that, in fact, this would amount to a breach of Article 8 rights.
Yes, absolutely. Absolutely.
Also, I found, sorry, I don't know if we finished with Wilson.
Yeah.
I mean, I also found a few other nuggets when I was looking at the recent decisions regarding deportation.
Yes, certainly been some quirky ones, hasn't there?
You certainly have. FS, and I'll get everyone the citation, against the Secretary of State, 2020 EWHC 1482. This gentleman was subject to a deportation order a long time ago. In fact, it was 10 years previously. And what had happened, that was in 2009, the decision was taken to deport him.
Yes.
However, because he was an Iranian national, the Secretary of State couldn't actually deport him. So essentially, he made a fresh application 10 years later, I suspect because somebody thought that he'd served his sentence, so to speak, although he had left the country, of making an application to actually revoke the deportation order. And what happened was, in fact, he wasn't given a right of appeal because, well, the Secretary of State refused it without a right of appeal, because what the Secretary of State said, look, there's been no change in your circumstances, just the passage of time.
Yes.
And therefore, you would have to show, basically, that either of two things. One, any delay in removing you was exclusively down to the Secretary of State and, in fact, not attempting to remove you, which it wasn't in this case. He literally physically couldn't be removed because of the nature of the Iranian regime.
And of course, the appellant didn't actually take the point. I think he ran it on the basis of the reason of the delay was irrelevant.
He did indeed. He just said that it's irrelevant. My 10 years is up. The difficulty with that is, of course, as we were just saying, it's a human rights application in the end to revoke the deportation order. And because his situation hadn't changed at all, the Secretary of State just said paragraph 353 applies. this isn't a fresh claim because you've adduced nothing new. The only thing you've adduced is the fact that there's been a delay, which of course you've benefited from because you haven't been deported, in actually removing you, and for reasons which are out of our hands. And what in fact happened was the Court of Appeal went along with that approach and actually said that unless, because you're quite right, Emma, it wasn't his case that the delay was due to the Secretary of State, but the Court of Appeal emphasised that if you were going to revoke a deportation order solely on the basis that time had passed, you better actually show that the delay was due to the Secretary of State, not to any extraneous circumstances, or indeed the appellant put it in a number of fresh appeals.
Yeah, she also made some interesting, the Court of Appeal also made some interesting comments about rehabilitation, and that was one of the points they made, wasn't it? That the absence of evidence of rehabilitation here distinguished it from previous cases like Gazon and I think it's MHT in Colombia, where there was a significant delay, but there was also significant evidence of rehabilitation. Here, there was an assertion of it, no further offending, but that was it. And the court said there needed to be more than just delay. Rehabilitation would assist, but there needed to be more, and that on its own wouldn't be, rehabilitation on its own wouldn't be enough.
What is, though, interesting is the court's focus on rehabilitation, because that goes back to some of the comments in HARAC.
Yeah.
Whereupon, and as you recall, the upper tribunal never actually put much store about the question of rehabilitation. But that, again, appears to be a change in the weather, so to speak.
Yeah, there certainly seems to be a bit of a change in the weather. And the court in FH, of course, make a number of points about the rehabilitation point. They say, well, you've got reasons for deportation. The first is to protect the public. Well, if you've got a long delay and someone who's rehabilitated, that public interest reduces down. And then they looked at other factors to do with the deterrence principle. And well, if you're not deporting people, you're hardly imposing the deterrence principle. But another point that the Court of Appeal made in this case to do with the delay, to distinguish it from other cases, was, well, hang on a second here, the Secretary of State hasn't done nothing for 10 years, 11 years. She made a deportation order quite promptly following your conviction. Yeah. She's just not, you obviously exercised your right to appeal, you're entitled to do so. He becomes appeal rights exhausted in 2009. It's very different to a situation where the Secretary of State fails to act for 10 years.
Well, quite, either by essentially issuing a deportation order, or then failing to follow it up with any action.
Absolutely.
Where things get put on the back burner.
I mean, to be fair, we know that with the state of Iran and diplomatic relations, there was a time when certainly nobody was being removed to Iran because the Secretary of State simply couldn't.
Quite. I thought that Emiantor, if I've pronounced it properly, which I doubt, against the Secretary of State, sort of dovetails into this a bit.
It certainly does.
2020 EWCA Civ 1461. Mr. Emiantor was basically detained before a deportation order was actually signed on him. He sued for, and indeed was awarded damages for unlawful detention.
I think he had an outstanding appeal at the Court of Appeal, didn't he, against his conviction? That's
right. And what happened was that the Secretary of State had given him a promise that he wouldn't be deported. And indeed, the deportation order was, I believe, cancelled due to the fact of the outstanding appeal.
It was, wasn't it? And then he went to report one day, didn't he? And an official decided to say that the case was over.
Yeah, and basically he then phoned the Home Office Information Service And they told him that, yeah, we're not deporting you. And on that basis, he claimed he had a legitimate expectation that he'd never get signed with a deportation order.
And in fact, I think that the Court of Appeal in their judgment accept the account of the events at Luna House, where he's told he doesn't have to report anymore. His deportation case has come to an end. The case is closed. They accept his account in relation to that.
They do. They're not challenging his account. But what they actually say is, look, verbal promises are not enough. And how many times, Emma, have you and I represented clients who've actually said, but I phoned the helpline and they told me this.
Yeah.
Well, it's actually not quite frankly, it's not worth the paper it's written on.
No.
Because essentially, the court ruled that you could only have a legitimate expectation if it was written down formally on paper.
Yeah.
Verbal promises were simply insufficient. And not only that, could not bind the Secretary of State formally if, in fact, one of the officials was merely giving informal advice.
Yeah, I think in this case, I think that what the Court of Appeal were particularly concerned about was that it wasn't a clear, unambiguous statement from the Secretary of State. And it was, well, they gave 3 reasons, didn't they, why it didn't give rise to a legitimate expectation. And the first was, well, the Secretary of State has a duty imposed upon her to deport foreign criminals, except in certain circumstances. And that none of those applied, obviously, here. And effectively, she was not following that duty by saying to Mr. Emiantor, I'm not going to deport you. And then, of course, I said, well, actually, you got a letter on the 23rd of August, 2016, I think it was, saying, we're withdrawing the deportation order and we'll consider the position post your appeal conviction. And there certainly wasn't anything written in that letter which said case is closed. And of course, there was no circumstances in this case which could lead someone to conclude on the circumstances of the case that there'd be no basis for the deportation to continue. And looking at all of those factors together, the Court of Appeal said, well, sorry, but no legitimate expectation, which is all rather unfortunate because he withdrew his appeal against conviction, it would appear, on the basis that the Secretary of State apparently told him she wasn't going to deport him.
Yes, well, that's rather unfortunate, but it illustrates the nature about relying on promises or indeed reading matters into documents which, quite frankly, are not there.
I think in the absence of a clear, unambiguous statement that the Secretary of State is not going to take any further action against you, I don't think you can proceed on the basis that there's any legitimate expectation that that won't happen.
Quite.
And I think that probably moves us on quite nicely to the case of Abidoye and the Secretary of State, the Home Department.
You've taken the words out of my mouth. That's what I thought too. Emma, would you like to sort of summarize this one?
Yes, interesting case. A gentleman who, I remember the year he was convicted, but a deportation decision pre-2012, succeeded in the first tier tribunal, obviously before all the rule changes brought in by the amendments on the 9th of July 2020 and the 2014 Immigration Act. Doesn't commit any more. 2012. 2012 Act, forgive me. And he doesn't commit any more offences, but the Secretary of State decides to have another bite of the cherry and make another deportation order, effectively on the basis the law has changed. Now, last year, 2019, we had the case of MA and the Secretary of State in the Court of Appeal, which was a statutory appeal in which the Court of Appeal said, the Secretary of State can do that. The law's changed. She can make another deportation order. This was a judicial review, which led to some rather scathing comments by Lady Justice Andrews about the use of the judicial review procedure here. But perhaps our more important point for the purposes of this was that the appellant, or the claimant in this case, attempted to argue that there was a case that hadn't been considered by the Court of Appeal in MA, the case of Harvey, I think it is, 2018 EWCA 2848, where there'd been a Zimbabwean gentleman who had avoided deportation on the basis that it would be a breach of Article 3 on the current circumstances. When the country conditions changed, the Secretary of State had another go, and well, the Court of Appeal seemed to think that was okay. But it was said that there need to be care taken when looking at different circumstances and change the law. But the appellants were basically trying to argue in Abidoye that Harvey said that hadn't been considered, and that would assist them in saying there could be a change in the law would prevent re-looking at the case. And the Court of Appeal said no, a change in the law is not something that would prohibit the Secretary of State looking at this again. If there's been a change in the law, it might be harsh to revisit someone's deportation who's succeeded, but in principle, there's no reason why the Secretary of State can't, even in the absence of any further offending.
Yeah, basically what they did emphasize, though, that there had to be a legal justification for the reopening of a deportation order, which quite clearly the Secretary of State had, because as the court pointed out, and as you just pointed out, the law had changed and there was nothing to stop the Secretary of State having a second bite at the cherry, so to speak.
No,
particularly because in one sense they were mandated to do so.
Yeah, I mean, the law now would indicate she's mandated to do so. And I mean, Mr. Abidoye received, I think it was 5.5 years in his case for involvement in quite a sophisticated fraud. It was something that was obviously going to be difficult for him to succeed under the new rules, but he had succeeded under the old rules.
Yeah.
But the Court of Appeal said, well, there's nothing preventing that. There has to be a justification, as you say, but the justification can be the change in the law, which is, in some respects, quite concerning for those who've succeeded previously in deportation cases where they haven't committed any further offences and have, been told they can stay in this country and have continued living their lives here in a law-abiding manner. But the Secretary of State can still have another go. Yeah,
the only thing is, of course, that there are all sorts of Article 8 factors that one would bring into this, and including what we were just talking about a moment ago, the question of rehabilitation.
Very much so. I mean, looking at the direction of travel in cases such as HA, Iraq, KB, Jamaica, and the rehabilitation factors that we've been talking about. And also there's an argument that you've been given an expectation that you can stay here. You've developed your family life further, and it would be the very compelling circumstances argument in reality, why you shouldn't now be deported despite the change in law.
Yeah, I think that's right. I suppose I ought to just mention a curious case which got to the European Court of Human Rights, and that's called UNUANE, UNUANE, against the UK, 80343/17. What was this all about is this chap got convicted. He certainly had British children. And basically what happened was, yes, the upper tribunal did an assessment of the wife, the children, and so forth under Article 8, and indeed found that removal, and I believe some of them didn't have any rights here, removal would be wrong in their case. But what happened with the appellant himself, who was of course the criminal, they never bothered with a proper Article 8 assessment.
No.
They just, basically there was no overarching Article 8 assessment. They just said, we've done the balancing exercise, you don't qualify, you're removed. And the difficulty with that, the Court of Appeal wasn't interested in the case for whatever reason. So they took it to Strasbourg, where, interestingly enough, a unanimous a European Court of Human Rights found that essentially, regardless of the merits of the case, you had to do an overarching Article 8 assessment, even if you didn't come within the immigration rules, and based on the principles laid out by the Supreme Court in Hesham Ali.
Yeah.
And that hadn't been done in his case.
Yeah, I think they made reference to the checklist in Balti and Switzerland and considering those factors, didn't they? And I think one of the difficulties we have with looking at the case almost outside of the immigration rules, I know deportation, you're probably a little careful about saying that, is that the starting point seems to be you don't meet the rules. And it almost seems to follow on from that there can't be a success because you don't meet the rules, rather than looking at whether there are actually factors in this case which mean, okay, you can't quite meet the rules, but there are these factors.
Yeah, there are other factors.
There are other factors here which do actually tip the balance in an Article 8 assessment in your favour, because, well, as we started off by saying, there needs to be a holistic assessment, and a rigid formulaic checklist doesn't cover all of those circumstances, and what's unduly harsh in one case may not necessarily be unduly harsh in another, and there needs to be that individualised assessment.
Quite. And what was surprising, of course, is that if you actually go to a case like Hesham Ali, which is quite clearly sets out the approach to deportation, and regardless of the statute, and they do hypothesize there may be some cases whereby if you do a proper Article 8 assessment, that you might not qualify under the rules, but you would succeed because of the extraneous factors which are brought into an Article 8 exercise.
Yeah.
I think we've been going for quite a long time, haven't we?
I think we have. Maybe we should wrap it up there for today.
Yeah, I think we should, because we were going to talk about deportation, and we have done.
Yeah.
So, under Section 117C and
Absolutely.
Article 8, of course.
Absolutely. Well, it's been a pleasure talking to you, Stephen.